Um, Justice Ginsburg, with whom Justice Stevens joins, and with whom Justice Souter and Justice Breyer join as to Part 1 dissenting. The Chief Justice acknowledges that provisions of Florida's election code may well admit of more than one interpretation, but instead of respecting the state High Court's province to say what the state's election code means, the Chief Justice maintains that Florida's Supreme Court has veered so far from the ordinary practice of judicial review that what it did cannot properly be called judging. My colleagues have offered a reasonable construction of Florida's law. Their construction coincides with the view of one of Florida's 7 Supreme Court justices. I might join with Chief Justice were it my commission to interpret Florida law, but disagreement with the Florida law's interpretation of its own state law does not warrant the conclusion that the justices of that court have legislated. There is no cause here to believe that the members of Florida's High Court have done less than their mortal best to discharge their oath of office, and no cause to upset their reasoned interpretation of Florida law. No doubt there are cases in which the proper application of federal law may hinge on interpretations of state law. Unavoidably, this court must sometimes examine state law in order to protect federal rights. But we have dealt with such cases, ever mindful of the full measure of respect we owe to interpretations of state law by a state's highest court. In deferring to states' courts on matters of state law, we appropriately recognize that this court acts as an outsider, lacking the common exposure to local law which comes from sitting in the jurisdiction. That recognition has sometimes prompted us to resolve doubts about the meaning of the state law by certifying issues to a state's highest court, even when federal rights are at stake. Notwithstanding our authority to decide issues of state law underlying federal claims, we have used the certification device to afford state high courts an opportunity to inform us on matters of their own state's law, because such restraint helps build a cooperative judicial federalism. I would have thought the cautious approach we counsel when federal courts address matters of state law and our commitment to building cooperative judicial federalism demanded greater restraint. Rarely has this court rejected outright an interpretation of state law by a state high court. As Justice Breyer convincingly explains, this case involves nothing close to the kind of recalcitrate by a state high court that warrants extraordinary action by this court. Recalcitrance? The Florida Supreme Court concluded that counting every legal vote was an overriding concern of the Florida legislature when it enacted the state's election code. The court surely should not be bracketed with state high courts of the Jim Crow South. The extraordinary setting of this case has obscured the ordinary principle that dictates its proper resolution. Federal courts defer to state high courts' interpretations of their state's own law. This principle reflects the core of federalism on which all agree. The Chief Justice's solicitude for the Florida legislature comes at the expense of the more fundamental solicitude we owe to the legislature's sovereign. Were the other members of this court as mindful as they generally are of our system of dual sovereignty, they would affirm the judgment of the Florida Supreme Court. I agree with Justice Stevens that petitioners have not presented a substantial equal protection claim. Ideally, perfection would be appropriate standard for judging the recount. But we live in an imperfect world, one in which thousands of votes have not been counted. I cannot agree that the recount adopted by the Florida court, flawed as it may be, would yield a result any less fair or precise than the certification that preceded that recount. Even if there were an equal protection violation, I would agree with Justice Stevens, Souter, and Breyer that the court's concern about the December 12 deadline is misplaced. Time is short, in part because of the court's entry of a stay on December 9th, several hours after an able circuit judge in Leon County had begun to superintend the recount process. More fundamentally, the court's reluctance to let the recount go forward, despite a suggestion that The search for intent can be confined by specific rules designed to ensure uniform treatment, ultimately turns on its own judgment about the practical realities of implementing a recount, not the judgment of those much closer to the process. Equally important, as Justice Breyer explains, the December 12th deadline for bringing Florida's electoral votes into Section 5 safe harbor lacks the significance the court assigns it. Were that date to pass, Florida would still be entitled to deliver electoral votes to Congress must count unless both houses find that the votes had not been regularly given. And then I think it's citing Title 3 of the U.S. Code, Section 15. The statute identifies other significant dates. See example Section 7, specifying December 18th as the date electors shall meet and give their votes. Section 12, specifying the fourth Wednesday in December this year, December 27th, as the date on which Congress, if it has not received the state's electoral votes, shall request the State Secretary of State to send a certified return immediately. But none of these states has ultimate significance in light of Congress's detailed provisions for determining on the 6th day of January the validity of electoral votes. The court assumes that time will not permit orderly judicial review of any disputed matters that might arise, but no one has doubted that good faith and diligence with which Florida election officials, attorneys for all sides of this controversy, and the courts of law have performed their duties. Notably, the Florida Supreme Court has produced two substantial opinions within 29 hours of oral argument. In sum, the court's conclusion that a constitutionally adequate recount is impractical is a prophecy the court's own judgment will not allow to be tested. Such an untested prophecy should not decide the presidency of the United States. I dissent. Justice Breyer, with whom Justice Stevens and Justice Ginsburg join except as to Part A1A, IA1, Part 1, whatever, and with whom Justice Souter joins as to Part 1 dissenting. The court was wrong to take this case. It was wrong to grant a stay. It should now vacate that stay and permit the Florida Supreme Court to decide whether a recount should resume. The political implications of this case for the country are momentous, but the federal legal questions presented, with one exception, are insubstantial. The majority raises three equal protection problems with the Florida Supreme Court's recount order. First, the failure to include overvotes in the manual recount. Second, the fact that all ballots, rather than simply the undervotes, were recounted in some, but not all counties. And third, the absence of a uniform specific standard to guide the recounts. As far as the first issue is concerned, petitioners presented no evidence to this court or to any Florida court that a manual recount of overvotes would identify additional legal votes. The same is true of the second, and in addition, the majority's reasoning would seem to invalidate any state provision for a manual recount of individual counties in a statewide election. The majority's third concern does not implicate principles of fundamental fairness. The majority concludes that the Equal Protection Clause requires that a manual recount be governed not only by the uniform general standard of the clear intent of the voter, but also by uniform subsidiary standards. For example, uniform determination whether indented but not perforated undervotes should count. The opinion points out that the Florida Supreme Court ordered the inclusion of Broward County's undercounted legal votes, even though those votes included ballots that were not perforated but simply dimpled, while newly recounted ballots from other counties will likely include only votes determined to be legal on the basis of a stricter standard. In light of our previous remand, the Florida Supreme Court may have been reluctant to adopt a more specific standard than that provided for by the legislature for fear of exceeding its authority under Article 2. However, since the use of different standards could favor one or the other of the candidates, since time was and is too short to permit the lower court to iron out significant differences through the ordinary judicial review, and since the relevant distinction was embodied in the order of the state's highest court, I agree that in these very special circumstances, basic principles of fairness may well have counseled the adoption of a uniform standard to address the problem. In light of the majority's disposition, I need not decide whether or the extent to which, as a remedial matter, the Constitution would place limits upon the content of the uniform standard. Nonetheless, there is no justification for the majority's remedy, which is simply to reverse the lower court and halt the recount entirely. An appropriate remedy would be instead to remand this case with instructions that even at this late date would permit a Florida Supreme Court to require recounting all undercounted votes in Florida, including those from Broward, Volusia, Palm Beach, and Miami-Dade counties, whether or not previously recounted prior to the end of the protest period, and to do so in accordance with the single uniform substandard. The majority justifies stopping the recount entirely on the ground that there is no more time. In particular, the majority relies on the lack of time for the Secretary to review and approve equipment needed to separate undervotes, but the majority reaches this conclusion in the absence of any record evidence that the recount could not have been completed in time allowed by the Florida Supreme Court. The majority finds facts outside of the record on matters that state courts are in far better position to address. Of course, it is too late for any such recount to take place by December 12th, the date by which the election disputes must be decided if a state is to take advantage of the safe harbor provisions. Whether there is time to conduct a recount prior to December 18th, when the electors are scheduled to meet, is a matter for the state courts to determine. And whether, under Florida law, Florida could or could not take further action is obviously a matter for Florida courts, not this court, to decide. Alright, last page and a half. By halting the manual recount and thus ensuring that the uncounted legal votes will not be counted under any standard, this court crafts a remedy out of proportion to the asserted harm. And that remedy harms the very fairness interests the court is attempting to protect. The manual recount would itself redress a problem of unequal treatment of ballots. As Justice Stevens points out, the ballots of voters in counties that use punch card systems are more likely to be disqualified than those in counties using optical scanning systems. According to recent news reports, variations in the undervote rate are even more pronounced. See Fessenden, no vote rates higher in punch card count. New York Times, December 1, 2000, page A29, reporting that 0.3% of ballots cast in 30 Florida counties using optical scanning systems registered no presidential vote, in comparison to 1.53 in the 15 counties using vote-o-matic punch card ballots. Thus, in a system that allows counties to use different types of voting systems, voters already arrive at the polls with an unequal chance that their votes will be counted. I do not see how the fact that this results from county selection of different voting machines rather than a court order makes the outcome any more fair. Nor do I understand why the Florida Supreme Court's recount order, which helps to redress this iniquity, must be entirely prohibited based on a deficiency that could easily be remedied. Despite the reminder that this case involves an election for the President of the United States, no preeminent legal concern or practical concern related to legal questions required this court to hear this case, let alone to issue a stay that stopped Florida's recount process in its tracks. With one exception, petitioners' claims do not ask us to vindicate a constitutional provision designed to protect a basic human right. Petitioners invoke fundamental fairness, namely the need for procedural fairness, including finality. But with the one equal protection exception, they rely upon law that focuses not upon the basic need but upon the constitutional allocation of power. Respondents invoke a competing fundamental consideration, the need to determine the voter's true intent. But they look to state law, not to federal constitutional law, to protect that interest. Neither side claims electoral fraud, dishonesty, or the like. And the more fundamental equal protection claim might have been left to the state court to resolve if and when it was discovered to have mattered. It could still be resolved through a remand conditioned upon issuance of a uniform standard. It does not require reversing the Florida Supreme Court. Of course, the selection of the president is of fundamental national importance, but that importance is political, not legal, and this court should resist the temptation unnecessarily to resolve tangential legal disputes where doing so threatens to determine the outcome of the election. The Constitution and federal statutes themselves make clear that restraint is appropriate. They set forth a roadmap of how to resolve disputes about electors, even after an election as close as this one. The roadmap foresees resolution of electoral disputes by state courts, but it nowhere provides for involvement by the United States Supreme Court. To the contrary, the 12th Amendment commits to Congress the authority and responsibility to count electoral votes. A federal statute, the Electoral Count Act, enacted after the close 1876 Hayes-Tilden presidential election, specifies that after states have tried to resolve disputes through judicial or other means, Congress is the body primarily authorized to resolve remaining disputes. The legislative history of the Act makes clear its intent to commit the power to resolve such disputes to Congress rather than the courts. Those who caution judicial restraint in resolving political disputes have described the quintessential case for that restraint as a case marked, among other things, by the strangeness of the issue, its intractability to principled resolution, its sheer momentousness, which tends to unbalance judicial judgment, and the inner vulnerability, the self-doubt of an institution which is electorally irresponsible and has no earth to draw strength from. Alexander Beckel, The Least Dangerous Branch, 1962. Those characteristics mark this case. At the same time, as I have said, the court is not acting to vindicate a fundamental constitutional principle such as the need to protect a basic human liberty. No other strong reason to act is present. Congressional statutes tend to obviate the need, and above all, in this highly politicized matter, the appearance of a split decision runs the risk of undermining the public's confidence in the court itself. That confidence is a public treasure. It has been built slowly over many years, some of which were marked by a civil war and a tragedy of segregation. It is a vital necessity It is vitally necessary ingredient of that successful effort to protect basic liberty and indeed the rule of law itself. We run no risk of returning to the days when a president, responding to this court's efforts to protect the Cherokee Indians, might have said, John Marshall has made his decision, now let him enforce it. But we do risk a self-inflicted wound, a wound that may harm not just the court but the nation. I fear that in order to bring this agonizing long election process to a definitive conclusion, we have not adequately attended to that necessary check upon our own exercise of power, our own sense of self-restraint. United States v. Butler, 1936. Justice Brandeis once said of the court, the most important thing we do is not doing. What it does today, the court should have left undone. I would repair the damage done as best we can by permitting the Florida recount to continue under uniform standards I respectively set.